Thank you for everyone for coming in. I know we're somewhat interrupting the lunch hour. And thank you for being here this afternoon. So welcome to the roundtable on adjudicating international environmental disputes. We are very privileged to have some amazing speakers that not only understand the theory, but have a tremendous amount of practical experience litigating precisely these kinds of disputes in various international fora. So what I'd like to do is introduce everyone, and they've already forgiven me for the brevity of the introductions on their profiles. You'll see in the written materials a full bio, so I will not remotely do them justice, but I'll introduce everyone. And then after a few remarks, we're going to launch right into a very, we hope, interactive session. Well, I'll just be throwing questions at people, trying to get them to talk to each other and talk to you. So my plan is to do about an hour and 15 minutes. Having this discussion up here, but I would like to reserve time for questions at the end of the session. I will be a bit of a stickler on how long the question/comment can be. So please, if you're thinking about it, do try to distill it down. But we do want to have an opportunity to talk to you and have a conversation with you about this topic. So let me start with Charles DeLeva, who's the former chief counsel of the Environmental International Law Practice Group in the World Bank and the legal advisor, and this is a mouthful, the Climate Change Solutions Area and Environment and Natural Resources Global Practice Group. He retired in December 2016 after an amazing 25 years of service and is currently an adjunct professor at AU. This is in no particular order, but Dan McGraw teaches at Johns Hopkins School of Advanced International Studies and previously was president and CEO of the Center for International Environmental Law. He also serves as a consultant to the United Nations regarding environment, human rights, and investment law. Andrew Lowenstein is a partner with Foley Hoag's International Litigation and Arbitration Department, where he focuses on public international law, as well as investor state and international commercial disputes, with a particular competence in international environmental law. Jimena Fuentes is the National Director of Boundaries and Frontiers, the Ministry of Foreign Affairs of the Republic of Chile. She served as the agent of Chile before the ICJ in the Chile v. Bolivia status and use of the waters of the Silala. She's a professor of public international law at the University of Chile and former co-rapporteur of the International Law on Sustainable Development Committee of the ILA. And last but certainly not least, Simi Payne. She's an associate professor at Rutgers. She's appeared as counsel before ITLOS in its deep seabed mining and fisheries advisory opinion cases, and she's currently the legal advisor to the International Union for Conservation of Nature's delegation in relation to the International Agreement on Biodiversity in the High Seas. So truly amazing panel, an amazing set of experiences. So what we're trying to do in this panel is bring the conceptual, which is one conversation in terms of the field of international environmental law, to the practical. Join the two, talk about jurisprudence, some themes, some progress, what's happened in the past and where we see it going. So as many of you know, over the past 5 years, there's been a marked increase in cases concerning actual or potential environmental harm being submitted to the ICJ and to other international courts and tribunals. And these cases have resulted in very important advances in both the substantive and the procedural aspects of IEL. They've also presented challenges to the international institutions that have considered them. So on one view, you think these cases illustrate a constantly evolving and increasingly sophisticated jurisprudence and continuing innovations on the procedural side to deal with environmental and increasingly climate change disputes. That's one view. On the other, these cases and the various judicial bodies and arbitral bodies and institutions that have considered them can only be described as fractured, and that they point to failures of the current dispute resolution systems and perhaps evidence only a deepening need for a standing, more permanent body, potentially a standing environmental court. So I want to start with, and then I'm going to sit down and really try to get the conversation going, with an overarching question relating to environmental harm claims. And Dan, I'm going to start with you. With your experience at CIEL, what do you think were the most effective environmental decisions for international tribunals? And do you think tribunals are developing a greater sophistication in dealing with these kinds of issues, Or do you think they're lagging behind? Why don't you start us off?
Thank you. And let me explain that none of us can look at anyone on that side of the room because we will be blinded. So you're going to get a lot of eye contact. Thank you. We only have 2 or 3 minutes, and to choose the most effective cases amongst the wide variety of cases is to some degree impossible, but let me mention a few. At the ICJ, the Gabčíková case was very important. It established the doctrine of intertemporal law, which we can talk about later, which is very important, especially in the environmental area, and it purported to apply the principle of sustainable development, which is also a challenge. In the trade area, I think the shrimp turtle case is of particular importance. Among other things, the panel there deferred to MEAs, multilateral environmental agreements, specifically CITES and the Convention on Biological Diversity, when confronting the question of whether sea turtles, in fact, deserved protection. So that was one important thing. It declared that there was an international requirement of due process, which is important in environmental and other cases. It defined a structure for analyzing and applying Article 20 of the GATT. So it's a very important case. Human rights cases, there are many that are dealing with with environmental issues right now. In this hemisphere, the San Mateo case, which was the first case that held, this was in the Inter-American Commission on Human Rights, the first holding that environmental harm can violate human rights. So that's very important. There are many other cases in the 3 regional human rights adjudicatory systems, and one of the interesting things is how they apply environmental standards, both domestic and international, including standards in instruments that are not binding on the defending country, but they use those standards to give some clarity or definition to the human rights standards, which, like human right to life, it doesn't contain a very specific standard. Domestically, there's the Juliana case, which is going on right now in Oregon. The claim, including by future generations, is that the U.S. government is violating the common trust doctrine. It's been allowed to go forward in a very thoughtful U.S. federal district court decision, and it has to do with climate change, obviously. And then I mentioned also the pulp mills case, again in the ICJ, in the International Court of Justice, which declared, much to many people's surprise, that there's an international customary law, general law requirement that countries do transboundary environmental impact assessments, and also emphasize the importance of due diligence in these kinds of cases. Thank you.
Thank you, Dan. You've definitely set the table, and you mentioned a few issues that we're going to get back to in more detail. But let me start with Jimena. How about from your perspective as a public official, what do you think have been the most effective decisions, and how do you generally view tribunals and their sophistication in environmental issues?
Thank you. Well, if you are, as I do now, a public official, and you are interested in assessing the impact of international case law in the field of environmental law, I think that if you adopt the perspective of the state, you would look with interest the decisions that deal with at least 3 issues or topics. One, you would be interested in looking at the development of new obligations under international law for states, or the further development of existing rules. You will also be interested in looking at those decisions where an issue of interpretation of international rules by international tribunals in a way paves the way for the application of those rules domestically. And in the third place, I think that you will like, or you will be interested in looking at how international environmental law contributes to the creation of obligations on the side of private actors in relation to the protection of the environment. So if you look at the present case law or the recent case law, I think that with regard to the first issue, the development of new international obligations, well, I think that an interesting case is the Nicaragua-Costa Rica decision. It is important because it establishes when states are really compelled to undertake an environmental impact assessment. With regard to the second element, the extent up to which international environmental law can be used domestically, or international law in general, I think that I would look carefully to any decisions by human rights courts or in relation to environmental issues, because every human rights court decision can be used domestically, since human rights treaties today are considered to be part of domestic law in most countries. In particular, I would have read with attention the Urgenda case in the Netherlands, because there the domestic tribunal started by applying the European Convention on Human Rights and then concludes that the Netherlands has to take measures regarding greenhouse gases emissions. And with regard to the third element, how international environmental law has developed obligations for private actors, here I would be particularly interested in looking at investment case law, counterclaims presented by states, in particular, well, the Perenco, the Burlington cases with Ecuador, and the recent Urbasser case with Argentina.
Thank you, Jimena. I can already see the patterns developing with respect to EIAs, developing norms, the intersection with human rights and domestic systems that I think we're going to come back to. Before we do that, I want to get everyone's thoughts on the table more generally. So Charles, from an IO perspective, you put on your World Bank hat. Same question: where do you think the tribunals have gone with it, and would you call it sophisticated approach to environmental issues?
Thanks, Catherine. And building off Dan's, some of the cases that Dan mentioned, but looking at it a little bit with the lens of a development agency, pulp mills was interesting for us because it was financed, the pulp mill was financed by the IFC, the bank's private sector arm. And the analysis, as you know from your work in that case, sort of used the environmental impact assessment policy of the IFC as the basis to look at the environmental impacts of the project. It also looked at the transboundary notification requirements using the La Plata agreement in its opinion, which therefore sort of justified the World Bank's approach on transboundary notification in international waters cases. Shrimp turtle was interesting, not just because of the affirmation of environmental issues and the reference to the Convention on Biological Diversity, but also from the development side. Shrimp turtle affirmed to the developed country members of the bank that it's useful for financial and development agencies to help developing countries be prepared for the obligations under the trade agreements. And that's reflected in the work that IFIs did under NAFTA and CAFTA when you think of the introduction of the requirements for effectively enforcing environmental law. The way for developing countries to do that is to have the capacity building that development agencies can provide. We're also, of course, very aware of the ICSID cases because ICSID's one of the World Bank Group members. Within the bank, when one looks at the inspection panel and the bank's accountability mechanism that's been around for almost 25 years now, in the early days, the environmental aspects tended to be the ones that they first dealt with. But when we look at the concept of international environmental disputes today, what I think is interesting is the social and human rights realm that's entered into this discourse. So just in the last few years, some of the most highly visible and contentious matters that were dealt with by the inspection panel involved potential of forced and child labor in Uzbekistan. In Uganda, where there were Chinese contractors who are increasingly a major player in Africa investment. And that means that there's various actors in the supply chain. Some of the local workers that were hired in that case were involved in cases of sexual abuse that wound up for the World Bank having to issue a major report on labor influx. In the Kenya natural resource management case, the question was really, while there were the project was supposed to help deal with the forest and watershed, it was really about land and indigenous rights. And several years ago, we had our own carbon rights case. And, you know, there's been indication in some of the discussions this morning and elsewhere about what's going to happen with climate-related disputes. And that was one where it really didn't have to do with climate impacts per se, but it was villagers who claimed that they weren't getting their payments under a carbon sequestration scheme. So that means that the sophistication of environmental disputes is going to have to reach out to other disciplines to be able to deal with the types and array of cases that we're dealing with, and also the fact that we're spawning new tribunals to deal with some of these issues, and we can talk about some of those later.
Just one quick follow-up, Charles. So do you think that that's happened already in terms of the cross-disciplinary approach, or is that a trend line that you think that we need to think very critically about?
It's already happened because, you know, for 20 plus years, the World Bank had basically separated the concepts of their environmental safeguards and their social safeguards. Starting next year, our board, as of about a year ago, has approved that we have a new environmental and social framework. So social inclusion, non-discrimination, women's rights, gay rights, the rights of the disabled are all built into this same process of looking at impact.
Thank you. So Simi, let me turn to you, and really same overarching question. And actually, while you're answering, I'm going to move back to the podium because I'm having trouble seeing. But please go ahead.
Okay. So I think I very much appreciate. First, I'd like to say thank you to you, Catherine, and to ASOL for the invitation to participate in this panel. I think Jimena set out some of the criteria very beautifully, and I would say that with Dan, that pulp mills was a very important case in terms of influence. It was really a dictum that EIA was an international, transboundary EIA was an international obligation, but we've seen that taken forward by other courts. And I think that's where I'd like to call a little attention. Not only has the International Court of Justice itself continued to develop that concept, but then we saw the Law of the Sea Tribunal pick it up in its first advisory opinion on deep seabed mining. And then this is where I think the taxonomy is kind of interesting. As Catherine said in the introduction, I've been participating in the negotiations on sort of preparatory work for negotiations on a new international agreement on sustainable use and conservation of biodiversity in areas beyond national jurisdiction, the high seas, which will be the subject of a panel tomorrow that you should attend. And in that context, we don't hear the Costa Rica-Nicaragua case referred to. We hear pulp mills and the Law of the Sea Tribunal's advisory opinion referred to frequently as the international law basis for including EIA in this new agreement that's potentially forthcoming. So there you see, I think, the important influence of the court. I think the pulp mills case is also the example when we talk about greater sophistication of international tribunals. There was a recognition, there was a failure of sophistication, which is in part remedied in the Antarctic whaling case, where we're seeing better use of experts, and we'll be talking about this further, I think, that today. I'd like to mention a couple of other points that the Law of the Sea Tribunal developed in its advisory opinions. One, developing the notion in the International Law Commission's articles on state responsibility, in talking about erga omnes obligations, which are very important as we're thinking of areas beyond national jurisdiction. And also this concept of due diligence, which was significantly developed within the ILC, but giving it real content in the context of these law of the sea obligations.
Thank you. So Andrew, I'm going to give you a slightly different cut of the general question. I want to focus on the ITLOS decision, among the most highly watched decisions in this space, in favor of the Philippines in the South China Sea context. How did the tribunal there incorporate or rationalize environmental law values?
Well, I think you're absolutely right to highlight the environmental significance of the South China Sea arbitration. The tribunal's ruling has received a lot of attention for its rulings on the legality of the 9-dash line and the maritime entitlements of insular features. But I think that the environmental significance of a whole host of rulings on obligations of states under Part 12 of UNCLOS really shouldn't be overlooked. One concerns the tribunal's confirmation that the obligations of states under Part 12 of UNCLOS apply to all states and apply in all maritime spaces. That's a very significant ruling because it enables claims to be brought even in disputed maritime spaces or indeed in areas beyond national jurisdiction. Another important ruling concerned the tribunal's approach to the obligations set out in Articles 192 and 194, both of which concern obligations of protection and prevention. There, the tribunal took the approach of interpreting those obligations by reference to obligations set out in other relevant international instruments. In this case, the tribunal paid particular attention to the Convention on International Trade in Endangered Species. That was particularly important for the Philippines because much of the claim centered on the environmental impacts on endangered species, specifically sea turtles and giant clams. And in interpreting the Article 192 and 194 obligations, the tribunal made the important ruling that in this context, the obligations of states apply not just to obligations not to cause direct harm, which in this case would mean harvesting of endangered species, but also obligations not to cause indirect harm, which in this case would concern the degradation of the habitats of endangered species. A third important aspect of the award concerns the legal obligation of states with respect to vessels bearing their flag that are engaged in unlawful fishing activities in the EEZ of other coastal states. Here, the tribunal picked up on legal standards that were enunciated in the previous ITLOS advisory opinion that was rendered in response to a request by the Sub-Regional Fisheries Commission, in particular in relation to obligations to ensure compliance with the laws and regulations of coastal states. And the tribunal picked up on this and applied it in the specific context of China's toleration of unlawful fishing by Chinese vessels in the Philippines EEZ. A final aspect that I think really exemplifies the environmental values, to pick up on an aspect of the question you asked, that really permeates the tribunal's award, concerns its recognition of the inherent interconnectedness of species and habitats, particularly in a biodiverse area like the South China Sea, and the legal implications of that recognition. The tribunal really sort of drew upon this concept of interconnectedness, which is defined by reference to important findings by experts, both submissions by the Philippines and by independent experts that have been appointed by the tribunal, and use that in the context of enunciating principles and obligations with respect to consultation and cooperation, which apply to states, particularly in areas like semi-enclosed seas.
Thank you, Andrew. So now I'd like to shift gears a bit and drill down on some of these concepts. And what most of you mentioned was the EIAs. For the audience's benefit, so in the Pulp Mills case, which again, most of you mentioned is a landmark decision. So here's the language about EIAs, the famous language. It may now be considered a requirement under general international law to undertake an EIA where there is a risk that the proposed industrial activity may have a significant adverse impact in a transboundary context, in particular on a shared resource. So Simi, you talked about the pulp mills and the EIA. You talked about Costa Rica and Nicaragua as a continuation of that conversation. Do we know the contours of that duty at this stage? Is there still debate around the acceptance of the use of an EIA for transboundary harm, or is it custom? Has it arrived? What do you think?
So what I'm seeing is, this reminds me of something that Joan Donahue, who is, as you all know, now a judge on the International Court of Justice, had said about how you tell whether international decisions are influential. And it's sometimes hard to tell, to trace through actions of states. It's very clear. I've been, sitting day after day in the discussions on the new treaty, possible new treaty, and there's constant reference to these cases as, yes, we must have EIA, and there seems to be a very broad consensus among the states in the negotiations that we should have EIA. The devil is in the details. What does that mean? Which activities within national jurisdiction that may have an impact on areas beyond national jurisdiction, or only activities in A, B, and J, areas beyond national jurisdiction? What's the threshold? Who will make the decision about whether the assessment is adequate? Who can participate? How much transparency there will be in the EIA process is a critical question that the details have yet to be sketched in. And it's clear from the discussions I'm seeing that in that forum, that there's going to be some serious differences of opinion about that.
Thank you. So Dan, in terms of the EIA itself, do you think tribunals are willing to engage in a substantive review of the EIA, or is it just a matter of assessing the procedure?
That's a very good question. And Simi's comments remind me that everyone is in favor of the rule of law, including the most despotic governments on earth. So it's a little the same with EIAs. Well, I think they will be filled out over time. One question is that the Pulp Mills Court left open is whether, for example, there needs to be public comment. I think most environmentalists would say that's an absolutely essential requirement of an environmental impact assessment, of a social impact assessment, of a sustainability impact assessment. You have to have it in writing, you have to have it comprehensive, you have to have it early, and the public has to have a chance to comment. But the court has not gone that far yet. I think it will eventually, partly because of the human rights to access to information and the human right to participate in decision-making. And it reminds me that the Pulp Mills case did not refer to the fact that virtually every human rights mechanism has held or said that there is a human right, that is an international human right, to have an environmental impact assessment done when an environmental harm might impact human rights. Now, that's not necessarily in the transboundary context. That's in any context, at least domestic context. So I think if we start applying the human rights rhetoric, not just rhetoric, but the standards, and I'd be interested if that was referred to at all in the negotiations, I think we'll find something. And also in Pulp Mills, as I said earlier, there was a real emphasis on countries doing due diligence. And that provides a standard. It's somewhat general, but it does allow a court to say, well, was there really due diligence in this, or was it a paper exercise?
So Simi, you've already mentioned that both the ICJ and ITLOS have at this point considered the question of EIAs. Andrew, let me get your further thoughts on that. Do you think at this point, is there a divergence in approaches? And to answer that question, do we need to take into account that the ITLOS decision was advisory?
Well, I think that there has been a convergence of approaches. You go back to the Pulp Mills case, the ICJ framed what it said about EIA relatively narrowly. It said that it relates to industrial projects in a transboundary context. ITLOS, in its subsequent advisory opinion, took the logic of that and applied it to other contexts. And it appears that the ICJ, in its more recent decision in the San Juan River cases, has adopted this more broad-based approach. But that's not to say there's not a degree of disagreement within the court itself on the precise nature or legal source of the obligation. Judge Donahue and Judge Iwata have both suggested that perhaps EIA is not a standalone customary international law obligation, but rather the means to fulfill a more general due diligence obligation. I'm not sure if that divergence within the court, if there is a divergence within the court, has much practical significance, since I suspect that all the judges would agree, and this is borne out in the separate opinions of Judge Donahue and Judge Iwata that they made in the San Juan River cases, that the state would be hard-pressed to see how a state could discharge those due diligence obligations if it didn't conduct an EIA. There is a degree of confusion, I think, that arose out of the Pulp Mills decision, and questions about whether the obligations with respect to the substance of the EIA should be defined solely by reference to domestic law, or whether international law also plays a role. And I think some interpreted that to mean it was really a reference to domestic procedures. I think that the more recent San Juan River cases have clarified that that's not the case, that the EIA, although generally done by reference to domestic procedures, needs to have regard for the nature and magnitude and context in which the proposed project is being undertaken. So I think that's a very important clarification that the court has made that provides very valuable guidance to states and when they contemplate projects that might be undertaken.
So Jimena, let me throw it over to you. It's been my experience that states are very particular as to what they think considers binding custom. And what do you think with respect to the duty of an EIA, whether it's a standalone duty, whether it's some aspect of a more general due diligence duty, has it reached the level of state practice and opinio juris to be considered custom?
Thank you very much. Well, I think that Timmy has made all the relevant questions with regard to environmental impact assessment. And she has said that the devil is in the details, and she's very right. So the question is, when are states compelled to conduct an environmental impact assessment? And the answer given by tribunals is, well, when there is a risk of significant environmental harm. And how do you answer the question then? When do you know when there is a high risk of environmental harm? And the ICJ in the Nicaragua-Costa Rica case said that, well, then states has to make a sort of a preliminary assessment. And only then we will know if they are compelled or not to conduct an environmental impact assessment. Well, here we have a strong difference with domestic law. And let me start with a reference to the differences between environmental impact assessment in domestic law and environmental impact assessment at the international level. Because in domestic law, you have interesting features that cannot be replicated in international law, I'm afraid. But in domestic law, when you develop environmental law domestically, you know that you can put in place agencies in charge of administering a system of environmental impact assessment. And you can have laws, statutes, and you can say, okay, this is a list of activities which the government, which the legislative thinks that inherently contain this risk of environmental damage. So if you want to proceed to conduct any of these activities, you have to have a prior environmental impact assessment. And if you don't have that assessment, well, then we will have to shut down your project because you have not complied with the requirements. Well, that is impossible to replicate in the international arena. I mean, in a perfect world, you would have probably a general treaty that will have a list of activities that inherently poses risks to the environment, and that states will be compelled to conduct an environmental impact assessment. Now, probably very few states will be willing to become parties to such a treaty. Then what we have? We have a system, the international system, where tribunals have attempted to develop some rules. And they have been successful in developing a rule according to which states have an obligation to prevent significant harm to other states. In order to comply with this obligation, tribunals have further developed a rule according to which states have to conduct activities in accordance with a standard of due diligence. And further in this path, when tribunals ask, what is due diligence? Well, in the end, due diligence is composed of a number of obligations of conduct, which in the end have been developed by tribunals on a case-by-case basis. Now, the standard of due diligence has allowed tribunals to create single obligations, and one of those obligations is the obligation to conduct an environmental impact assessment. Now, is this customary law? Well, I think that they have followed a different source of law because there is no evidence of practice or opinion juris regarding environmental impact assessment. Now, states will not object to this way of creating obligations, particularly because many states, or at least some states, states that in their domestic law, they already have the obligation of conducting environmental impact assessment for activities conducted in their own territory, well, they will not object. I mean, it's a sign of the times. Now, I think that with these developments, it would be very difficult in the course of time to disentangle due diligence from environmental impact assessment. So I think that this has been a very successful way to create obligations for states.
Well, Jimena, you've very eloquently and diplomatically thrown a grenade into the conversation on EIAs, which I want to give Charles an opportunity to respond, and then would like to shift to another topic. But go ahead, Charles, please.
Just quickly, notwithstanding Simi's correct point that the devil's in the details, for those advocating support for the pulp mill's opinion, which is 2010, for over 2 decades, you have about 189 member countries of the World Bank and the other development banks around the world who've all agreed to be bound by the obligation to do environmental impact assessment. And I think at least in the Inter-American Court, they have referred to that accepted requirement as supporting the customary international law aspect of EIA, and it includes going beyond the boundary. So I think that's useful to point out. Sorry.
No, thank you. So let me switch gears to another very pressing issue, which is climate change related disputes. Charles, I want to start with you, particularly at the World Bank in your role with the Green Climate Fund, but more generally, dispute resolution and where it intersects with climate change disputes. Do you think the dispute resolution mechanisms, whether it's before international courts or ad hoc tribunals, has that helped or hurt the pursuit of the climate change objectives post-Paris?
The types of disputes that are likely to arise are going to be of such a wide and as yet unknown variety that I think it's difficult to say we should have this or that specific kind of tribunal. The cases involving the new renewable energy regulation in Ontario are one example of types of disputes that, in the case of the Mesa Power case or the Windstream Energy arbitration, that within a short period of time, one province produces regulation that is of great contention. And as I referred earlier, the kinds of issues that are likely to emerge under emissions trading matters, whether it's between states or private entities, or in the case of RED plus, issues that are dealing with land rights, compensation, are likely to be in a wide variety of contractual issues, in which case sometimes there may be no question about the particular global warming impact. It may be just pure negotiations, so you don't necessarily need environmental expertise. But there may be others where whether a sequestration activity is adequately sequestering the right amount of carbon requires that kind of expertise. So I think at this stage, it's difficult to say. The Green Climate Fund, in its negotiations with the accredited entities, has referred to the PCA arbitration rules, but not the environment rules per se. And I think that's probably because of what I've just described. And they've even negotiated that there can be different venues for the source of arbitration. So I think it's the beginning of a complex landscape. There is the reference in the UNFCCC arbitration provision that gives countries the opportunity to use arbitration if they choose, and then also encourages other ways of mediating disputes.
So just one follow-up on your point about the adoption of the PCA arbitration rules, but not necessarily environmental rules. I think you've described why that may be the case. Do you think other arbitral institutions should try to develop the PCA type specific environmental rules, or is it really just a matter of the general rules would suffice and you just have to think about the sophistication of tribunal members?
I think that there is such a large climate-specific world that's evolved since 1992 with such a large array of decisions and practices under the Kyoto mechanisms, and there will be a new mechanisms under the Paris Agreement, that rather than develop specific chambers, I think it's useful for these disciplines to start finding ways to be ready to call on each other, and the use of the right expertise, so that when these disputes arise, and they can arise at any time because Paris allows, really, if you will, for early action, if I can use that term. So it's probably useful to have that. The other thing that's probably could give us more information is if the 6 or 7 carbon trading disputes that have gone into arbitration were publicly available, we might know a little bit more, but none of those have been disclosed.
No, that's right. Simi, let me turn to you. So we've talked a lot about what the international conversation has been in terms of international bodies. I want to turn a little bit to the domestic, specifically with respect to climate change disputes. I think there's certainly been an uptick in domestic courts being more willing to take jurisdiction in these kinds of cases, more willing to take on this often very confusing, highly technical scientific evidence that underpins. Do you think, one, do you agree with me that that's a trend? And two, how does that influence international bodies? Do you think that's something that promotes the idea for international bodies to both take jurisdiction and to deal with this complex scientific evidence?
I think that there is an important difference between the domestic courts and the international courts. And so we're seeing gradually more cases in domestic courts, it's true. In a sense, I would turn to a case like the US Supreme Court case of Massachusetts versus the Environmental Protection Agency, which was, of course, for us a watershed case by the court saying to the Environmental Protection Agency, yes, climate change is real. Greenhouse gases can be a pollutant, and therefore you have to consider them, regulating them under the Clean Air Act. And so there, the court was in the position of being able to refer to the Intergovernmental Panel on Climate Change's work in a kind of general way. And I think that that's the kind of thing that we can see international courts doing comfortably, partly because the IPCC's work is not only a collection, a review of hundreds, sometimes thousands of peer-reviewed scientific papers, but it also goes through a process that gives it the imprimatur of states, because there's a final review by states of the final product. And it doesn't require, there's a summary for policymakers, it's about 30 pages long, and it doesn't require review of thousands of pages of documents. So I think those are easy cases, and you can see that happening. I think the more difficult cases are the ones where a court might be asked to determine causation. A terrible cyclone that affects Myanmar and gives rise to claims of liability against greenhouse gas emitting states for not responding to the problem. Well, there you have difficult causation problems, and we can imagine, as we've already heard, many different iterations of this kind of problem. I think those are going to be the more challenging ones, and I don't think that the methodology that the International Court of Justice was able to use in the Antarctic whaling case of looking at the scientific methodology and judging whether that was adequate can get you very far down the road. So I think it's going to be hard for them.
Thank you, Simi. So I want to spend at least a few minutes on the tricky concept of sustainable development, which I think has only grown in importance over the years, especially in recent years. So Dan, I want to turn to you. You, I know, negotiated and drafted some language in the Copenhagen Declaration on Social Development in 1995 to the effect that sustainable development includes environmental rights. Can you describe the context for that discussion? And in your view, how close are we to a definition of sustainable development that takes into account environmental rights? And is that a desirable outcome? That's a three-part question, Dan, but you're up to it.
And I have 2 minutes. The context there was in 1992, it seemed that the world community had adopted sustainable development as the paradigm for trying to improve the standard of living of people around the world. But there was significant pushback from developing countries, especially in New York, with the officials there, arguing that sustained economic growth is really the paradigm. And that came to a head in Copenhagen in 1995. And for the first time ever in a United Nations document, the heads of state agreed that sustainable development was the paradigm, and that it required integrating economic, social, and environmental policies and laws and that sort of thing. And that, of course, included human rights. So that was the context. The fight wasn't completely over. Although I should say that in negotiating this, I found that the closer I got to a head of state, the more it was obvious that sustainable development required integrating those three things. They said, well, of course, we have to think about more than economic growth. How do you think I stay in power? And it didn't matter if that was a democracy or a totalitarian state, but the lower level officials were seemingly enamored with this economic growth model, the sustained economic growth. So that was the background. Now, as I said earlier, in the Gabčíkovo case, the International Court of Justice purported to apply sustainable development as a principle. Now, as a lover of sustainable development, I think that's nice in the abstract, but the question is what it means. And there is no agreed definition of that term. One can look at the different international statements about it and I think come up with 4 parameters, one being you needed the integration I mentioned of economic, social, and environmental. The second is that you need to think about future generations. A third is that we should give priority to the world's poor, in particular the people in absolute poverty. And the fourth is that we have to protect the environment to a certain degree. We cannot fix everything technologically. But having said that, those are not particularly applicable norms. It's hard to say they are. So Von Lowe has called this a sort of a mega principle, and I don't know what it means, but it sounds like he might be right. The World Court wants to use it. It was applied in the Kishinganga arbitration between Pakistan and India. I should say, by the way, that each of us has participated in some of the cases we're discussing today. We didn't think it made sense to go through individually and give disclaimers on each of those, but just as a general disclaimer, for all of us, that's right, including Catherine. But it wasn't clear exactly what it meant there, and in the end, the Court of Arbitration, I think, backed away from a specific application of it. So it does raise issues. I wanted to add one more thing. We haven't really focused on transparency here, although there was one reference. And sustainable development, I think, involves public participation. It involves transparency. And one of the truisms, if you will, of environmental protection and human rights protection is that they have required the participation of civil society. And so in all of these cases, I think transparency is a very important issue. It varies the amount of transparency, including whether amicus briefs are allowed, varies greatly among these different tribunals that we're talking about. So just keep that in mind. Thank you.
Thank you, Dan. And yes, I neglected to mention at the outset that everyone's speaking in their personal capacity and nothing should be attributed to any of the cases in which they have worked. So because we like the controversial principles as we go through this field, I want to talk about the idea of changing norms, which seems to have a lot of traction, in particular in the environmental context. And one example, just one, is the concept of inter-temporality. And which posits that treaties need to be interpreted in light of changing norms. Some view this as a simple treaty interpretation exercise. Others really accuse this doctrine as a backdoor in terms of creating new obligations that states really didn't have in mind when they signed treaty or didn't rise to the level of custom. So Dan, just going back to you on this one, how do you think this concept has played out in environmental cases? And is there any other context outside the environment where we've seen this applied? And what does that mean for the principle?
You point to a very important problem, which is the fragmentation of the international legal system. And one evidence of that is the number of tribunals that we're just talking about here, and the dichotomy, if you will, between human rights treatment of environmental impact assessment and the world courts and the domestic and international layers that were also referred to. And there are a couple of ways of dealing with that. One is through the Vienna Convention on the Law of Treaties and in Article 31. Another is what the International Law Commission has called the harmonization principle. And the third is, or a third, is what the International Court of Justice called the principle of intertemporal law in the Gabčíkovo case, and it's been applied in subsequent cases, primarily environmental cases. The idea here is that as norms develop, including particularly environmental norms, then earlier treaties, that is treaties that that were negotiated long before these norms came into existence, like Principle 21 on transboundary harm, like the environmental impact assessment requirement, that those norms should be read back into those treaties. Now, all of you public international law professors, you know the issues that raises, and probably all of you do. I mean, the countries haven't necessarily, that negotiated those treaties, haven't necessarily agreed to that. And again, in the Kishinganga case, which dealt with water in Kashmir between Pakistan and India, this came up again. And the treaty has a little on environment, but it doesn't have as much as it would be if it were negotiated now rather than in the 1950s. And the Court of Arbitration, in a way very consistent with Gabčíkovo, said, well, we're going to interpret that treaty in light of these new norms. And one can argue, well, the new norms developed and there's some implicit consent to have it read into previous treaties, but you can see the challenge. And I think what it reflects is the recognition that environment in particular is the real infrastructure of society, given the kinds of ecosystem services that nature provides us and how we couldn't exist as a civilization without them. And so we need somehow to reconcile that reality with these earlier treaties. So that's what's happening. And I don't know of any situations where that doctrine has been applied outside of the environmental area, but the Vienna Convention and maybe the harmonization principle have been used to interpret treaties in a way that's consistent, I think, with that principle.
So Dan, just a few sentences. Why do you think that is? Why do you think that this principle, that's arguably an overarching one, has only played out for the most part in environmental jurisprudence?
Could you repeat that? I'm sorry.
Sorry, I guess the question is to your last comment that we haven't seen this in context outside of environmental. Why do you think that is? It is ostensibly, it could be characterized as a general principle. Why do you think we've seen it arise really in the environmental context when it comes to evolving norms?
Yeah, well, I'm not sure, and maybe someone in the audience in the Q&A can provide an example, but I think it's where these issues arise. And so therefore the question is, well, should have there been an environmental impact assessment or that sort of question? I think it's because of the specific issues that arise. Okay.
So Jimena, over to you. I want to talk very in a concrete context about changing norms. So that's with respect to international water disputes, which you have a particular expertise in. How does the human right to water, which I think is now recognized by most countries, play into such disputes? And I realize there's pressures around it. There's privatization of water services, scarcity issues. But how does that potentially evolving or perhaps arrived right to water play into these international water disputes?
Well, here probably we will move a little bit away from international environmental law only. But as I said at the beginning, states probably are looking with great interest the developments about human rights and business. Companies may have obligations under international human rights law or under international environmental law. So suddenly, everybody is saying that we have new norms compelling companies to conduct themselves in a certain way. Now, with regard to investments in the water sector and in general in the field of concessions regarding public goods, we have seen that the participation of the private sector or foreign investors have not always been successful. A number of cases before investment tribunals illustrate the kind of problems that the privatization of the water industry may give rise to. And in all those cases, the state, of course, has to intervene. Probably the state has to take measures that will affect investors in order to secure that the communities will still have access to water or they still will have a sewage water system. The problem is that investors might seek the protection of an investment treaty and take the dispute to arbitration. So in these cases, the solution to the problem requires state action, administrative measures, and as we heard in another panel, probably a balance between the interests of the state and the interests of the investors. But it seems that investment arbitration or investment rules are not well equipped to solve the dispute, because to solve them, they would need to understand the complexities of the regulatory norms that states apply in these kind of situations. Normally, the regulatory authority will take into account the rights of the investors, but it will also take measures regarding the infringement, for example, of domestic law. And the problem is that breaches of domestic law by the investor normally will not be a relevant element in investment arbitration. The question then is, can we balance the rights of investors with the obligations of the state to regulate a particular sector of the economy? And it seems to me that the answer to this interesting question, or in answering this question, there has been an attempt to answer the question by resorting to the idea that investors have human rights obligations, or that investors have obligations in the field of the environment. So they are trying sort of to balance this by saying, well, the state has obligations, the investor has obligations. And I think that the Urbaser case with Argentina illustrates this way of tackling the problem. But I think that it's wrong. I think that the answer is not there. The emergence of the issue regarding human rights or environmental obligations of private companies is a symptom of a serious pathology, I think, of the whole system of investment arbitration. I think that investment arbitration is a great mechanism to solve disputes between states and investors, in which the investor claims that the state has not respected its rights or its right to be treated fairly, with fairness. But investment arbitration is not the place to solve complex issues of domestic, administrative, regulatory law. So if we want to find a place where to solve problems having to do with the regulation of projects in the field of water, electricity, or other public goods, I think that we should think of another model of tribunal, perhaps an international administrative tribunal with judges, with arbitrators that will be people with experience in the field of regulation, not in the field of investment treaties. So sorry for being a little bit radical.
Not at all. Not at all. But why don't we pick up on that for a moment? To you, Andrew. I know we were going to talk about investor treaty arbitration. So there has been, again, I think, an uptick of environmental claims, whether it's by investors or counterclaims by respondents. We have the Parenco or Basel Burlington tribunals specifically wrestle with that. Any thoughts in response? What are the trend lines that you see there? Or should there be an entirely different system, or is the current investor dispute system something that you think has competence to deal with these issues?
I think environmental issues can, generally speaking, come up in two different contexts. You often have claims brought by investors that relate ultimately to environmental issues. Denial of an environmental permit, cancellation of a chemical registration, things like that. These matters are often brought under claims for indirect expropriation or violation of fair and equitable treatment of the investor's investment. Those issues implicate environmental concerns and require a certain degree of technical facility on the part of a tribunal. But in this context, due to the general deference given to states to enact regulatory measures, the standard of proof is relatively minimal in the sense that the state really only needs to show that the regulatory measure was non-arbitrary. It's a different situation when you have claims brought affirmatively by states against investors. Of course, it's all very fact-specific, but for example, in the context of claims for environmental torts, you have often complex technical issues about causation, application of municipal law to the complex factual circumstances, which require a quite high degree of technical facility. But what we've seen is tribunals adopting measures that can serve to help address these potential problems. For example, the adoption of presumptions. So in the Parenco case, for example, the tribunal said that there was a strong presumption that if there was a regulatory exceedance, then there's a presumption that the investor is at fault. So that serves to alleviate some of the technical issues that might face a tribunal. Another way that a tribunal can handle these sort of situations is to appoint, assuming it's permitted by the relevant procedural rules or by the BIT or by the relevant convention, to appoint an independent expert that can advise the tribunal on the technical aspects of proof. So there are strategies that tribunals can adopt to address these issues. I would also say that there is a responsibility of counsel to think about these issues as well. If you anticipate that there's going to be complex technical or scientific issues, then that should be taken into consideration when appointing arbitrators or discussing who would be potential presidents of tribunals. So there are ways that the parties themselves can ensure that there's a tribunal that's competent to handle these types of issues.
Thank you, Andrew. I think I'm cognizant of the time remaining, and I want to make sure that we get to our wrap-up question because I think it's important. But I don't want to leave this conversation without at least talking a bit about issues of proofs and modalities of proving such claims in this context. We've talked about it a little bit already, but Dan, let me turn it to you. What are the greatest challenges in your mind for proving factual elements in environmental cases, and how can those challenges be met?
I think Andrew ably presented a major issue, and that is that many of these cases, which are very fact-specific, are also scientific evidence-specific. And I understand that in the pulp mills case, one side submitted 10,000 pages, that's 10,000 pages of scientific evidence, and the other side, perhaps in retaliation, submitted 20,000. But I'm not sure of the timing. In any event,
they were doubly right, Dan. That's how it worked.
So I'm a counsel for one of the parties. We can't expect the International Court of Justice to the judges anyway to sort through that. And in that case, in fact, Judge Sima filed an opinion where he raised the question of the competence of the court. And there are techniques of dealing with that. As Andrew said, the court can appoint an independent expert. You can have a flash situation where you get the independent expert and both sides expert and have them go at it. In the Kishinganga case, we had expert statements, written statements on each side, and then the Court of Arbitration insisted on having those people testify, and when one of them wouldn't come, they invalidated all of that testimony, that person's testimony. So there are ways that the tribunals can control this, but it's very difficult. And it's, again, I think Andrew mentioned this, these questions are very complex because nature is interdependent and complex. And there are many relationships we don't know. We can see them in retrospect, why they existed. I mean, there's a beautiful YouTube about how the introduction of wolves in Yellowstone changed the shape of the river. And it's very clear in retrospect it wasn't predicted. So that makes it difficult. And then the presence of uncertainty, one of the two big surprises when I came from academia to the government is how uncertain regulators, the kind of uncertainty they face. There's always, literally always uncertainty. And that's, tribunal members don't like that. I don't blame them, but there it is. And so, and they're not trained in these areas. So I think that's an additional challenge. And then I would say that we, in the Kishinganga case, we had a site visit, and I think there have only been a couple. One in Gabčíkovo, where the International Court of Justice went to the dam site, and one in Kishinganga, where we visited both Pakistan and India. And those can be effective, but they raise some questions as well. And there's a great article by Sam Wordsworth about what happened in the Gavjakovo case, not a bad thing that happened, but how to do those that I recommend to you if you're interested.
Thanks, Dan. Andrew, a yes or no question at this stage, which is the ICJ whaling case, first ever cross-examination. Is that something that you think should continue, or is that an innovation that should continue, or is it really just point out perhaps the incompetence of the ICJ in dealing with that kind of examination? What are your thoughts?
I think it's a really important precedent and serves as a basis for really successful subsequent proceedings, particularly in the later San Juan River cases, where the parties' experts were subjected to cross-examination by counsel, but also by questions from the court. I think I counted 9 questions from judges to the party-appointed experts. And I actually think it actually made a difference. I think it crystallized in the court's mind some of the key issues. I'm thinking particularly of Costa Rica's argument in the certain activities case that Nicaragua should have conducted a transboundary EIA. That was a really hotly contested issue, subject to extensive expert reports. It emerged during live testimony during the oral proceedings that Costa Rica's expert agreed that ultimately there was no risk of significant transboundary harm from Nicaragua's dredging project. And the court picked up on that in its judgment, and so that it confirmed the approach that had been adopted by Nicaragua's regulatory authorities.
Thanks, Andrew. Charles, from the IO perspective, are there particular tribunals with innovative procedures that we haven't mentioned yet?
I think there are. Also, just, one thing that we could try to take advantage of in this type of situation is the use of at least objectively neutral other international organizations with expertise. I mean, you have WHO on health, you have UNEP that could provide expertise in a case, I think, such as what Andrew is referring to. And the advantage of doing that is, I think, you bring transparency into the process, because unlike that, what would seem to be a little bit of a self-selected process or done within fora that are not really that available to the public, if you reach out to these other organizations that have very often been doing work in transboundary impact for decades, as UNEP has done EIA guidelines over 30 years ago, you can take advantage, or whether it's ILO, and that then helps do upward harmonization and cross-fertilization. In the case of the World Bank Inspection Panel and the other MDB's inspection panels, some of the innovations are to bring experts from both sides before the panel and allow the experts to do an open discussion that avoids sort of the adversarial setting of cross-examination. And as long as there's opportunity to, as they have done in some instances, is prepare a factual record and give an opportunity for the other side to view it. I mean, I think that can really produce an outcome that is shared and is progressive. The other thing that I think we shouldn't ignore in our discussion, especially in an audience such as this, is the obligation, perhaps in the investment community, but certainly in the developing countries, to bring more judicial capacity building to the domestic courts. So perhaps there's going to be, over time, less frustration with the fact that local impacted communities don't seem to have a voice. I mean, that's what spurred the discussion this morning on investor-state arbitration. It's a lot of what we're talking about here. There's an imbalance. There's these tremendous panels of experts in some of the investor states, and the sense that the impacted community, if these public health or environmental regulations are undermined by the panel, that the community's voice isn't heard. So one way to do that is to focus more on capacity building. And the one other innovation I'll mention, which comes out after the 5-year process of developing the new environmental social framework at the World Bank, is site level, project level grievance mechanisms that are funded, that are available, that are transparent, and then help avoid the frustration that sometimes builds up when it goes up to these other more distant types of tribunals.
Thanks, Charles. Simi, could we just get a couple of minutes on the UN Compensation Commission's procedures in handling the 1991 Gulf War environmental claims?
Thanks. So briefly, the UN Compensation Commission, some of you will have heard about from a previous panel. It was established by the UN Security Council as part of the deal that ended the 1991 Gulf War from Iraq's invasion of Kuwait. And it dealt with many issues other than the environment. But in the environmental context, it reviewed over 6 years, 168 claims for environmental damage. And the three commissioners who were the judges, essentially there, if I may say, each had vast environmental experience. So I'd like to point out generalist judges, that's often a concern. They had over 100 years of experience between them, and yet they found it very useful to bring in a large number of independent experts to advise them, because they had issues on everything from groundwater contamination by the destruction of Kuwait's oil fields to the sludge that was damaging the desert from the oil well fires, to oil spill damage along the Saudi coast, and the question of whether that could be remediated. So there were issues of verification of the facts, of causation, causal links, and finally something that we haven't really talked about, but I think is equally important, is fashioning remedies and understanding how to fashion a good environmental remedy if a tribunal has the opportunity to go beyond satisfaction or financial compensation. So the appointment of independent experts, I think, can be enormously useful.
Thank you. So that brings us to the forward-looking, the future of these kinds of disputes. So do we need a change? Do we need, and this is not a new idea, but it seems to persist year after year, a standing international environmental court? And I'll ask all of you to comment on that. Dan, you want to take it? And feel free to answer yes or no.
I'm going to take the position there should be one, and generally speaking, I like things to be integrated, but what we're seeing is the increasing siloization, if you will, if that's a word, of dispute settlement around the world. There are all these bilateral investment treaties, 3,200 now, most of which provide for investment tribunals. There's the WTO. There are different regional and bilateral trade agreements that have their own dispute settlement mechanisms. There's the World Court, inspection panel. I could go on, all these tribunals you've heard about, plus others. And so why not have an environmental court that actually is composed of experts, that's familiar with how to use environmental expertise, is familiar with dealing with uncertainty, with interrelationships and that sort of thing. And it could serve either as a court of original jurisdiction if there were situations where those kinds of interstate claims arose, for example, or it could be a tribunal that other tribunals would refer issues to for quick resolution.
Thanks. Simi, do you agree?
No. I think, you knew that was coming. I think it's a general matter that it's important for courts of general jurisdiction to continue to develop their environmental expertise. So there may be certain issues, just as there are certain issues that are appropriate to come up to a trade court, there may be certain issues that are so uniquely environmental in nature that it's appropriate to have a special court. But I think it actually flies in the face of sustainable development to think we can separate environment out from social and economic concerns.
Andrew?
I would also say no for two principal reasons. One, I think that the current system and the current set of courts and tribunals is more than capable of handling these types of environmental cases. I would also be concerned about the implications for legitimacy of judgments if there was a new environmental court. and what the implications would be for the legitimacy of environmental decisions by courts of general jurisdiction.
Thank you. Jimena?
Well, as I am a public official, I will not say yes nor no.
Understood.
So my contribution would be that it is interesting that in the that in the Kishanganga case, I mean, that was a court of arbitration, and that one of the members of the tribunal was an hydrologist. And I think that he made a great contribution to the final decision of the court. I have been, I was, for a year, I was sitting in the environmental tribunal in Santiago, in Chile. This is a domestic tribunal. And I remember that we were three judges, 2 lawyers, and one was supposedly a scientist. It could be also an economist, but someone that could deal with the technical aspects of cases. And at first I was very skeptical about the influence or the role of this third scientific judge. But in the end, I think his or her contribution was important to understand the scientific background behind these kind of disputes.
Do you think, and in your experience, that having that scientific expert on the court gave that person an outsized role in deciding the dispute? Because if an issue came up that was contentious, that person could say, well, because science. Was there that interaction?
Pardon? I didn't take the last part.
In terms of the interaction between the lawyers and the scientist, did that change the role of the scientist in the decision making, so that the scientist perhaps had an extra role in saying on an issue that could go one way or the other, it should go the other way?
Well, the thing is that if you have a scientist sitting in a court, the other judges will rely on his or her judgment in order to assess the evidence that is being submitted to the court. So it will give you, someone to resort to, someone that is credible, and someone that is impartial. Because one of the problems with scientific evidence, with evidence in general, that is provided by the parties, is that if you're a judge, your position should be, well, should I believe him? Should I not?
No, that's right.
So in this case, you have someone that is reliable.
Thank you. And Charles, back to the larger question, court, yes or no?
I think the answer, in a perfect world, we would just have one international court, period. The environment is just too multidisciplinary to, I think, have an international environmental court. Because the world's not perfect and we have the WTO system, it's understandable why we would want an environmental one to possibly balance some of the concerns in the trade world. But then we have an ILO system, and now we can increasingly see Inter-American Court of Human Rights, OAU human rights system looking at environmental issues. So we've also got the complexity of, if you're asking that question, well, what are the human rights various tribunals going to answer, because they would feel you were taking away from their ability. The Inter-American Court of Human Rights just heard a case on Colombia's request on right to environment advisory opinion. So it's just too siloed now. In the World Bank context, again, if it was a perfect world, we just have one World Bank, but we have many regional development banks. Now, maybe that's fine, but it just shows that governments aren't there. It's not going to happen. So I think we need to focus on building up capacity and transparency, access to justice, and moving funds into that, making that a criteria for future negotiation of some of the business investor type agreements.
Okay, so 3 against 1 and 1 abstention. Let me just ask very quickly before we open up for questions, who in the audience thinks there should be a standing international environmental court? Raise your hand. I can barely see you, so forgive me if I can't count. 1, seriously. Who disagrees with it? Okay. And who has no opinion on the matter after having heard from our experts? Okay. All right. Well, that's definitely interesting to me. Please join me in thanking our panel. I am going to take the chair's prerogative until we're basically pulled out of this room and just allow time for a few questions. Please use the mics on either side. And I apologize, I cannot see. So even if I know you, please state your name and your question. And brevity is appreciated. Please.
Hi, Steve Wolfson.
Got it from both sides.
And this question goes back to the discussion earlier in the panel about assessing impact and preventing harm. The World Health Organization is increasingly identifying air pollution as a leading cause of premature mortality. They're giving estimates in the millions. Though often we don't know who the victims are. So the question I have is, how do the obligations you were talking about at the beginning of the panel on assessing impact and preventing harm apply to those facts? And does it matter that many of the impacts are within the countries that are allowing the pollution, but some of the impacts are in neighboring countries or even across oceans? And to what extent does it matter that, from a legal standpoint, that the impacts often fall most heavily on the poor or on other vulnerable subpopulations?
Thank you. And I'm just going to take a few questions, then open it back to the panel. Please go ahead.
Just a quick question, Marcus Gearing from Bickle. A two-folded question. Do you think the SDGs can help us shed some light on sustainable development and move it from Vaughan's interstitial norm character to something much more concrete? And the second question is, do you think the South China Sea Tribunal's use of CITES in order to shed some light on law of the sea obligations could also be used in other contexts? So could the Paris Agreement influence the way we read international treaties such as ITLOS?
Thank you. So why don't we take it back to the panel? We have 3 questions. Whoever would like to answer.
I guess on SDGs, I think the answer's yes, because I think they represent the progressive consensus at the global level on, when one looks at the Rio principles and how they, in a number of cases, have been reaffirmed as customary international law, and the SDGs also give you the ability to look to global consensus. You know, the balance between hard and soft law, UN declarations, UN resolutions, treaties, they vary depending on the audience. So it is a useful tool. It has had consensus, and it can be used in the right arena. And depending on the issue that you deal with, maybe it can be quite concrete. It depends whether it also finds reflections, as some of the elements do in the SDG on energy in the Paris Agreement. So they reinforce each other. And to that extent, I would answer your question, Marcus, on the Paris Agreement to say, certainly it would seem to fit with the inter-temporality principle. And again, one has to look at the strength of consensus and the fact that you have 195 countries, notwithstanding Nicaragua, agreeing in Paris. Yes, it does give you that ability, I believe, to influence in other tribunals.
Thanks, Charles. I think we have time for one more comment. I've been given the universal symbol of we must cut it off, but Dan?
Let me just follow up on that. I mean, we've heard several examples of where tribunals are incorporating environmental standards. One is shrimp turtle, another is South China Seas. The Philip Morris case that just came down incorporated a WHO report, relied on it, and the Framework Convention on Tobacco. And the human rights cases are even incorporating the Rio principles. I think Jeff Kovar's over there who negotiated those, and I would bet he did not think that some of those would be used as standards to hold countries liable, but maybe I'm wrong. In any event, that's quite possible, but it doesn't always work. In the EC Biotech case, the World Trade Organization did not refer at all. I mean, it said it would not, literally the panel said it would not refer to the protocol on the Cartagena protocol. So it doesn't always work, but it's possible, and Paris will probably be used sometimes and not others. In terms of the impact on the poor, I mean, many people are concerned about environmental justice. And one has to look for norms that actually can be applied rather than general principles. But of course it matters that vulnerable populations are frequently the most impacted, and it's something we have to be alert for and try to counter.
All right, thank you very much. And please join me again in thanking this panel.
Thank you. I thought it was at 9.